Hello and welcome. City staff has been working on a review of the city's tree bylaws for the last couple of years, and the new council-approved tree protection bylaw comes into effect on January 1st, 2021. This presentation will give you information as arborists working in Ottawa on the new tree bylaw and what has changed. Ideally, we would be doing this together in a room, but unfortunately that isn't possible this year. If you have questions, please note them down. An email address will be provided at the end of the presentation. Any questions that we get by the end of day on Monday, December 14th, we will answer in a Q&A document that we will send out to the full group. But of course, you can ask questions at any time beyond that date too. We're here to help. The presentation will start with some background on tree bylaws in Ottawa and how we got here. It will go over what is new and how the new tree protection bylaw applies. New application and permitting details will be discussed, and at the end we will go over two common tree permit application scenarios. To start, the Ontario Municipal Act gives municipalities in Ontario the ability to enact bylaws to protect trees. The city currently has two tree bylaws in place. The Municipal Trees and Natural Areas Protection Bylaw was enacted in 2006 and protects all trees on city property citywide. Permission from the city is required to remove all city-owned trees. The Urban Tree Conservation Bylaw was enacted in 2009, and it covers trees on private property within the urban area of Ottawa. It is applied based on property size and tree size. Neither of these bylaws have had a fulsome review since their inception. The Urban Tree Conservation Bylaw particularly was designed to address the issues of the day when it was developed, and given the steady pace of infill development in the last 10 years, those issues have changed. In 2017, Council approved an urban forest management plan for the City of Ottawa. The UFMP is a 20-year strategic plan for our urban forests that provides recommendations on how urban forest management in Ottawa can be improved. One of the key recommendations of the UFMP was to do a review of the city's tree bylaws, with a sharp focus on the Urban Tree Conservation Bylaw. Staff had been observing problems, and key stakeholders were seeing clearly many ways in which the Urban Tree Conservation Bylaw had not been meeting the objectives that it set out to meet. The Tree Bylaw Review Project was launched in early 2018, and like the UFMP, it has been a joint project between the Public Works Department and the Planning, Infrastructure and Economic Development Department. In addition to improving the effectiveness of the existing tree bylaws, the project had a specific focus on also redesigning the processes to implement the tree bylaws. A strong and effective tree bylaw with clear and consistent implementation will help to ensure that the city continues to meet the goals identified in the Urban Forest Management Plan. Early on in the project, staff conducted a study in partnership with Carleton University to measure tree loss between 2008, so the year before the Urban Tree Conservation Bylaw came into effect, and 2017. In several inner urban neighborhoods where we had been seeing and hearing about increased levels of tree loss. Over the 9-year period, between 30 to 58% of the trees sampled in 2008 were lost and not replaced by 2017. In both Wellington Village and Westboro, this was confirmed to be a loss of just over 40% of the canopy for those neighborhoods. These results drove home the observation that tree loss has been happening at a much faster rate than it should be, and it showed us that we need to make some changes to better ensure that we are actively retaining existing healthy trees in the urban area. The intention is that the new tree protection bylaw and the associated implementation processes will do just that. Ottawa's new tree protection bylaw was approved by Council on January 29th of this year for implementation on May 1st. 2020. At that time, staff had proposed a new bylaw with many key changes and with the distinctive tree diameter remaining at 50 centimeters. It was intended that the new tree protection bylaw come into effect on May 1st, but of course the pandemic changed that. Staff realized early on in the pandemic that it would not be possible to implement a new bylaw on May 1st. In June, a motion was passed at Council that directed staff to implement the bylaw on January 1st. The motion also directed staff to decrease the distinctive tree diameter to 30 centimeters for the inner urban area at that time. So when the new tree protection bylaw comes into effect, within the inner urban area, the distinctive tree diameter will be reduced to 30 centimeters or greater. The distinctive tree diameter will remain at 50 centimeters or greater in the suburban area. In terms of the timeline moving forward, we are now in the midst of training on the new bylaw and all the associated new processes, and the new tree protection bylaw will come into effect on January 1st. So in terms of where we are now, the two existing tree bylaws have been put together into one harmonized tree protection bylaw. This harmonization gives us a more consistent and streamlined bylaw. Fundamentally, the new tree bylaw will function the same way in that it has parts specific to municipal trees, municipal natural areas, private distinctive trees, and trees on property greater than 1 hectare. The benefit of one bylaw is that it means there is one definition section, one section for exemptions and for enforcement, and one section outlining tree protection requirements, all of which apply to all parts of the bylaw. The overall objective of the review of the tree bylaws and of the urban forest management plan as well was to develop a more integrated approach to protecting Ottawa's urban tree canopy. The idea is that we take a somewhat of a hierarchical approach. We are calling it retain, replace, renew. The first goal is to retain existing trees on a site. Where that is not possible, any trees that cannot be retained will be replaced through compensation planting. And then, always, ongoing tree planting or renewing to increase the diversity of the urban forest is key. Through the implementation of the new tree protection bylaw, the focus will be first on that first goal to protect and retain existing healthy trees. The new tree protection bylaw is the key regulatory tool that the City of Ottawa has to protect the urban tree canopy. It represents a key component of the guiding council policy for city and private trees in Ottawa. Many elements of the original bylaws remain unchanged in that there are still sections for city trees in municipal natural areas and for private trees in the urban area based on property size and tree diameter. There have been big improvements on tree protection and on the administrative aspects in terms of how the bylaw is implemented. And moving forward, there will be a focus on enforcement. The new tree bylaw was developed through a team approach, including staff members in several city departments, consultants that reviewed existing bylaws and practices and reported on best practices in other municipalities, as well as an external stakeholder group who provided regular feedback and outreach to the public for feedback as well. Let's get into what's new. I will cover this at a high level now, and then more detail will be covered throughout the presentation. The new tree bylaw has clearer and improved tree protection requirements. In the current bylaws, it was clear that protecting trees was required, but they were short on details of what that meant. The new bylaw has a full part dedicated to how trees must be protected. This gives staff more ability to have oversight over tree protection and the ability to fine based on inadequate tree protection. The distinctive tree diameter minimum has been reduced from 50 centimeters to 30 centimeters within the inner urban area, which is the urban lands within the Greenbelt. This focuses on protecting trees that will be the urban forest of the future. In the suburban area, distinctive trees are still 50 centimeters in diameter or greater. The rules for private trees on properties greater than 1 hectare in size remain unchanged. The new bylaw introduces a new tree information report, or a TIR. The TIR will provide better tree information under different scenarios, and it replaces the Arborist report and the tree disclosure report. Now a TIR will be required to obtain a tree permit for the removal of distinctive trees in infill development scenarios and situations unrelated to development, as well as for the removal of city trees as applicable. The TIR will be covered in detail a little bit later in this presentation. The new tree bylaw has new and higher application fees to ensure cost recovery. The new fees are based on the reason for tree removal, no development versus infill development, and they reflect the complexity of the review and the staff time associated with that review. Trees will be considered much earlier in the infill development process. Tree information reports will now be required to be submitted with Committee of Adjustment applications so that the committee can take trees into account in their decision making. A new infill forester has been hired, and they will review Committee of Adjustment applications for tree impacts, working closely with the city's Committee of Adjustment planners. The tree permitting process will now be integrated with the demolition permit process. Forestry will be a clearance agency in that process. A demo permit does not equate to a tree permit, and tree protection must be considered in demolition projects. The processes for integrating trees into the building permit review have been improved. There are now 3 forestry inspectors who are focused on infill development specifically, and who will be reviewing development applications for building permits and working with applicants and building code services staff to minimize tree impacts to ensure adequate protection. Permits will now be issued for the removal of city trees. In the past, an approval from forestry was given, but now an actual permit will be issued, like the distinctive tree permits. There are new and formalized tree compensation requirements for when trees are permitted to be removed. Compensation was always required for the removal of city-owned trees, and there are now new compensation requirements for the removal of privately owned trees in the form of ratios for replacement planting. Details on compensation will be covered a bit later in this presentation as well. There is also a new requirement to post a tree removal notice directly on the tree permitted to be removed, in addition to posting the regular posting of the tree permit. Now some detail on how the bylaw applies across the city. For city trees, all trees on city property are protected within right-of-ways, parks, natural area, and forested areas, and this applies citywide across urban and rural areas. For private trees, the new bylaw has a sort of transect approach, which is in line with the city's new draft official plan. For properties 1 hectare or less in size, and for multi-residential properties, in the inner urban area, a permit is required to remove trees 30 centimeters in diameter or greater. In the suburban area, a permit is required to remove trees 50 centimeters in diameter or greater. For private properties greater than 1 hectare in size, the same provisions remain in place and a permit is required for all trees 10 centimeters in diameter or greater. And as before, in the rural area, there is no permit requirement for privately owned trees. This shows how the bylaw applies on maps. So for the full city, a permit is required for all city-owned trees. For the inner urban area, on properties 1 hectare or less in size, a permit is required for trees 30 centimeters in diameter or greater. For the suburban area, on properties 1 hectare or less in size, a permit is required for trees 50 centimeters in diameter or greater. So this is urban lands outside the greenbelt or the suburbs. This slide outlines permit exemptions. The tree protection bylaw includes a list of exemptions, situations where a permit is not required. Most of the exemptions in the bylaw are statutory, meaning that they are required to be included by Ontario's Municipal Act. The exemptions can be found in sections 81 and 82 of the bylaw. In summary, tree permits are not required for work under the Electricity Act, so work to keep lines clear done by Hydro One or Ottawa Hydro. For trees that are an immediate threat to public health and safety, as confirmed by an arborist. So this would mean that the likelihood of failure is imminent under normal weather conditions. The presence of anything or a person that could be harmed is constant or cannot be moved, and where access to the area that is under risk cannot be restricted. The consequence of failure is severe to extreme. And permits are not required for dead trees, also as confirmed by an arborist. A dead tree would be a tree that during growing season is leafless, showing no buds or signs of life, has brittle twigs and branches. And outside the growing season, there would be no live green buds, no fresh green material on twigs, brown brittle branches, detached bark, exposed wood. If you're removing a tree under one of these exemptions, you should be sure to record your assessment of the tree with the address and any other relevant information. You should take photos of the tree to show the reasons for your assessment. Keep your assessment and the photos on file and provide them to the homeowner in case they get questions. When you are removing an exempt tree, please call 311 and give the address of the exempt tree and explain the reason for the call. They will tell you how to submit the information so the ward forestry inspector is aware. A permit is not required to do regular tree maintenance and pruning, as long as it is done in accordance with good arboricultural practices. We'll now get into tree permit applications. So you will now be able to submit your tree permit application, which includes the tree information report, online. Previously, the application form and the tree information would be submitted separately, but now these will be submitted together with one online form. One application form will be submitted per site, but it can include several trees as necessary. The tree information report is new, and the tree bylaw includes a set of guidelines for how to prepare a tree information report. The TIR will detail all tree removal and tree protection for a site as applicable. There are two versions of the TIR, a short version and a full version. The version required will depend on the complexity of the project. For regular distinctive tree permits, for example, for residential backyard trees, the short TIR will be required. The short TIR replaces the old Arborist report. For infill development scenarios or for demolition, a full TIR is required. This is because more information is required in these development type situations, so the full TIR replaces the old tree disclosure report. The new application fee is a fee per tree. We will walk through the new fees in the next slide. This table shows the new application fee structure. Please note that this is an application fee, not a permit fee. For tree removal requests unrelated to infill development, so just a regular tree removal situation, the application fee is $150 per tree up to a max of $750, and this is for each city trees and private trees. For tree removal requests related to infill development or demolition, the application fee is $500 per tree up to a max of $2,500. And again, this is for city trees and private trees. We are referring to infill development a lot. Infill development means new low-rise residential development that is not subject to the site plan process under the Planning Act. So it would go up, one of those applications would just go through building permit and maybe the committee of adjustment. This would be new singles, duplexes, and triplexes. If the tree removal is associated with a Planning Act application, so for site plan or plan of subdivision, the permit fees are included within the development fees and there is no separate payment required. For trees that are exempt from the bylaw, no permit is required. Therefore, there is no application fee. Again, this is an application fee, and the fees have been set based on a cost recovery approach, recognizing the city resources that go into the application review and permit issuance process. As such, there are no refunds on these application fees, for example, if a permit is not issued. Now we will look at the tree compensation requirements. For city trees, the compensation requirements are unchanged from what is currently required. For the removal of a city tree, evaluation of the tree will be done by the city using the trunk formula method. The compensation will be the value of the tree plus the cost of a replacement tree, which is $400. The tree protection bylaw includes new compensation requirements for private trees. It is a ratio approach and it's based on what is happening on the site. So for a non-development situation, the compensation requirement will be a 1-to-1 replanting. For each distinctive tree removed, one tree must be planted in its place. For infill development and demolition situations, the compensation ratio will be higher and will depend on the size of the tree. So for trees 50 centimeters or greater in diameter, the ratio for replanting is 3-to-1. And for trees 30 to 49 centimeters in diameter, the ratio for replanting is 2-to-1. It's likely that it won't always be possible to plant the full requirement for compensation trees on a smaller development site. And in that case, the applicant will have to pay the replacement value of those trees not planted, which is $400. So for example, for a 56 centimeter tree, the compensation could be 3 trees planted, or 1 tree planted and $800 paid for the other trees, 2 trees not planted, or other such combinations. These compensation requirements are in place as per the direction from the city's official plan and the council-approved urban forest management plan. And the idea is to reflect an appropriate loss in canopy cover and to compensate for that loss through tree planting or monetary contribution to tree planting. Now moving on to enforcement. Of course, we always work to avoid situations where trees are damaged or removed without a permit as required. However, it is inevitable that bylaw infractions occur. Under the new bylaw, infractions are generally the same as previous. For example, any work or excavation within the critical root zone, damaging a protected tree, and of course, unauthorized tree removal. The regular fines are the same and they can range from $500 to $100,000 as per the Municipal Act. And special fines have been added in cases where there could be an economic or financial gain from contravening the bylaw. Now we're going to talk in more detail about the new tree information report requirements. There are several changes to our tree information report requirements and how the information is submitted. For the old process, we requested an application form and a separate arborist report, whereas our new process, we are asking for one consolidated form that includes the application information and the tree information. Either the arborist or the homeowner can submit the application, which hasn't changed from the old process. However, whoever submits the application will be the one who is sent the invoice. With our old process, the application form and the arborist report were submitted as a scanned image via email to forestry. But with our new process, the TIR will be an online form and all of the information will be able to be collected electronically through that online form. The last change to highlight is that with our old processes, we did not require TIRs for city trees or demolition permits. However, with the new processes, TIRs will be required for all application types, except site plans and plans of subdivision, which is a separate process through the planning department. There are two versions of the tree information report, the short version and the full version. The short version of the TIR applies to all application types except infill development and demolition. These application types include the non-development applications, so any run-of-the-mill tree removals and any type of construction that is not related to an infill development application. The full version of the TIR applies to infill applications and applications for demolition. So for the short version of the tree information report, the following information will be included. The contact information for the owner, arborist, and if known at the time of application, the contractor. This would include names, addresses, telephone numbers, and email addresses. Specific information about the trees on the site is required, such as tree species should be included as both the English name and the botanical name. Ownership for each tree must be listed within the report, listing private, city, boundary, or adjacent. If ownership is unknown, a survey may be required. For trees on a shared property line, the shared address must also be listed. For size, the diameter of each tree must be measured at breast height and be provided in centimeters. Tree condition. Applications for tree removal based on condition must now provide greater detail on the conditions noted and may require additional documentation, such as tree risk assessments, to support the arborist's recommendation. The determination of the condition will be based on factors such as structural integrity, percent deadwood, vigor, pest infestations, significant lean, and so on, and should also consider the level of risk associated with the condition and whether any mitigation options are available. The location of trees to be removed must be included in relation to existing and any proposed structures, lot boundaries, or relative proximity to other trees. The client's reason for removal. Examples could include for construction purposes, so for a new house, landscaping, or for safety. If the tree is potentially hazardous, the concern must be identified. The arborist recommendation for the tree, as well as any protection and/or mitigation measures to be implemented for retained trees on the site. Any additional information that may be relevant. At least one photo per tree with a visual of the reason for the tree removal request. And the arborist tree information report attached that was used to fill out the application online. Even if the arborist is the one submitting the online TIR form, they should still attach the arborist report. It's especially important if the homeowner is submitting the TIR that they attach the arborist report so that it's clear that they are submitting information prepared by professionals. It's important to note that whoever has submitted the application form online is the person that will be invoiced for the application fees, so please keep that in mind. Now getting into the full version of the TIR. All the information from the short TIR needs to be included, plus plans showing the tree locations. The tree locations need to be shown on the grading plan and on any site plan submitted for the site. Details for tree protection and any required mitigation measures for trees being retained on the site. These must be shown on the relevant plans as well. Boundary tree confirmation. When tree removal is requested for a boundary tree, permission of the other owner is required. There will be a form available for the other owner to sign to indicate that they are in agreement with the removal of the tree. And tree replacement. the full version of the TIR will need to contemplate tree planting. The plans must indicate where trees will be planted, how many, and the species and size of the trees to be planted. This would be coordinated with the compensation requirements, and the tree bylaw gives guidance on minimum standards for replacement trees. This is a draft copy of what the online TIR form might look like. It's still being updated, so it may look a little bit different once it's online. But as you can see, it includes the documentation pieces we just reviewed, and all of this information will be collected electronically. Now we're going to move into when permits, and therefore tree information reports, are required. We have seen what the bylaw boundaries are, and this slide summarizes that with a little bit more detail. So for city trees, all trees are protected regardless of property size, location in the city, or tree size. But when is the tree information report required? TIRs are always required for any construction that is not related to infill development, for infill development, and any demolition applications. The only scenario that may not require a TIR for city trees is the no development scenario. Most of the time, city tree requests result in forestry performing regular maintenance or removals. Situations that may require a TIR include fixing water or sewer services. For city trees unrelated to infill development, it's always a good idea to call 311 to find out how to proceed, for example, if a TIR is required or not. The city's tree protection bylaw website will include an online decision tree that will walk through a set of questions and determine whether a permit is required or not. Once tree size, property size, ownership, and location of the tree in the city, i.e. interurban, suburban, or rural, have been inputted into the decision tree, it will know if the bylaw is applicable to the request or not. Arborists and residents can use this tool to decide if or when they need to submit their TIR online. Now for private trees. So for private trees located in the urban area, on properties greater than 1 hectare, and for properties where there's a site plan or plan of subdivision application, all trees 10 centimeters or greater are protected. But these do not require a TIR as they fall under the site plan process, which is a separate process requiring a more detailed tree conservation report, and all requests should be redirected to Planning Forester Mark Richardson. For properties 1 hectare or less in size, and for multi-residential properties of any size, within the inner urban area, all trees 30 centimeters in diameter or greater are protected. And within the suburban area, all trees 50 centimeters in diameter or greater are protected. Both require a TIR for tree permit requests. And for the rural area, the bylaw is not applicable to private trees and no tree permit or TIR is required. Again, the new decision tree on the city's website will be very helpful to determine how the bylaw applies to a particular situation and what is required for your application. Okay, this is a set of general rules for considering tree permits that the city has developed. When we talk about this diagram, though, there are many disclaimers to make. This is not necessarily something that can happen on every site at all. This is simply an ideal approach and will always depend on site-specific elements such as tree condition, health, species, size, location, on the site characteristics, and on the proposed development. The point is, this provides a transparent starting point for setting expectations around what the city will or will not permit to be removed, and it helps to show that the city will be making efforts to retain more trees, particularly in infill development scenarios. The hope is that over time, applicants will start to come in with plans that protect healthy trees rather than plans that require clearing of the full site at the onset. The diagram here gives good guidance for that. This example is specifically for an infill development scenario, but the concept of it really could be any project, an addition, a new deck, a driveway, a walkway, or a larger site plan. Let's take a look at the diagram. Starting with the tree located in the city's right-of-way along the street in front of the house. This is a tree that the city will be focusing on keeping, so saying no to a tree permit. This is a city-owned tree, the city has been maintaining it, and it provides an important benefit as part of this streetscape to the community and all who travel on this street. Any development would have to consider this tree early and protect it adequately in the design of the site and also through the construction process. Then if we look at the back of the property, this tree is in the rear yard amenity area, and like the street tree, it is providing benefits not just to this property, but to several neighbors that back onto this property. These small urban forests that are located in the middle of blocks in rear yards of mature neighborhoods make a really important contribution to Ottawa's canopy cover. For that reason, this would be a tree that the city would be asking to be protected during any development on this site. Then we move into the yes tree that is located within the as of right building envelope. This is where the city would say yes to a tree permit. This tree is located in the area of the site that has already been indicated as the location for a building. So to develop the site, this tree will have to go. Then there are the two to be determined trees, which are located quite close to the as of right building envelope. These are tricky because in this diagram, they are likely within the excavation zone for the new foundation on this site. It will depend on the site, the development, the trees, and so these will be site-specific decisions. Then we have the boundary tree at the back of the property. This tree is jointly owned between the subject site and the adjacent property behind. The city will not issue permits for boundary trees without the approval of both property owners, so that would be required in this case. And the default would be to indicate clearly that this tree needs to be protected adequately. And finally, the toughest one of the bunch, perhaps, the adjacent tree. The trunk of this tree is completely located on the adjacent property, but the critical root zone of this tree extends onto the subject site. This tree must be protected. The city would not issue a permit for the removal of someone else's tree. If the roots of this tree are cut to the property line, that would be a violation of the bylaw and actually likely result in a dangerous situation. So trees like this will have to be protected in development situations on small sites like this, and the advice of arborists on how to protect this tree will be so important to infill developers. So this recognizes that trees can be removed in certain general parts of the site and when there's no reasonable alternative. But there are parts of the site where, if there is a healthy tree present, the city is looking to see tree retention, and that may require some creative design and doing things a little differently. When trees are identified for retention, the next step will be to ensure that adequate tree protection is possible and that mitigation measures are identified as required. This diagram will be on the city's new tree bylaw web pages. Staff and applicants will take site-specific situations and work to implement the intent of this as appropriate. The reasons for removal that will generally be considered include causing structural damage. So this could be in regard to property, foundation, and so on. The condition of the tree, if dangerous, injured, or dead. For development, so for site plans, infill, pools, and so on. However, as the previous slide said, the city will be looking for tree retention on these sites as well. For city projects, such as infrastructure projects, for right-of-way approvals, like underground bell utilities and so on. For water services not related to development, so for repair, etc. And some other reasons that are listed in the bylaw include if removal of a tree is necessary to remediate contaminated soil, if the applicant has undertaken to implement satisfactory landscaping, replanting, or tree preservation on the site, and if there's no reasonable alternative. For this, it will be important to show that alternatives have been assessed and that there are, in fact, no reasonable alternatives. Decisions will always be made on a site-by-site basis. So this is what the new tree permit will look like. The permit will be in both English and French. There will be 3 parts to the front of the permit. These parts include the header, the permit details, and the legal statement. Looking at the header of the permit first, we have the permit name, which is new. It used to be named Distinctive Tree Permit, but now it is Tree Removal Permit since the permits are also required for city trees. We have the permit number, the issuance date that the permit was, and this is the date that the permit was received by city forestry staff, and we have the expiration date, which is set for 1 year after issuance. At the bottom of the permit, there is standard wording that appears on all permits. The standard wording states that the bylaw authority for the new tree permit is the Public Works and Environmental Services General Manager. But if you have questions about a tree permit, please contact the forestry inspector listed on the permit. And the legal statement, which covers risk and responsibility, and of course, the posting requirements. Then the information within the permit listed within the permit details includes the name of the property owner, the location, which is referring to the address of the property, the tree reference number, which is an internal identifier, specific tree information such as species, size and diameter, and location on the property, the reason for removal, and the permit conditions will show as codes on the permit, which will be determined by the forestry inspector, and we'll go through those codes in more detail in a few minutes. The last bit of information included is comments and permit issued by. This will indicate the name of the forestry inspector on the file and any other relevant information such as site-specific conditions. One point to emphasize here is that when a permit is being issued and there is a development happening, development will be the reason for removal. Even if the TIR states that the tree has structural problems or something else, the point that will be considered is, would that tree be coming down if there were no development happening? For reporting purposes, it's important for the city to know where development is impacting trees. The permit conditions will show in two different locations on the permit. So under permit conditions, they show as codes or numbers, and under comments, they may show as text. So these are site-specific conditions. They could be related to a particular situation, like a mitigation or a protection measure that have been discussed with the applicant or recommended by the arborist. The legend for the condition codes is printed on the back of the permit. There are two types: standard conditions, which will be included on every permit, and selected conditions that are related to compensation and will be selected on a site-specific basis. This legend shows the 9 permit codes and their definitions. The first 5 are the standard conditions, and they cover adhering to the bylaw, tree protection, tree planting specification, wildlife impacts, and adhering to other legislations and regulations. The last 4 are chosen based on the compensation requirements and the combination of tree planting and monetary compensation for a site. As we've discussed, the compensation will depend on the application type and whether the tree is city or privately owned. The requirement to post a tree removal notice is new under the tree protection bylaw. This was done in order to better notify the public, councillors, and neighbors of the removal. The tree removal notice must be posted on the tree itself. The tree removal notice will be included as the second page of the permit and will also be fully bilingual. There are 3 parts to the notice: the header with the notice title, the description of what the notice is for, and the permit information. This includes the permit number, the date of issuance again. This is the date that the permit was received by city forestry staff, the address, the tree information, including species, size, and diameter, and of course the reason for removal. It is the applicant's responsibility to post this notice. On the back of the tree removal notice, you will find the posting instructions for both the permit and the public notice. So the instructions for the tree removal permit are as follows. The permit must be posted for each tree in a prominent location, same as before. The permit for each permitted tree must be posted 7 days prior and 7 days after the removal of the permitted tree. The permit must be kept legible at all times, and it may be laminated or protected as may be required. The posting instructions for the new public notice are similar but slightly different than the permit posting instructions. So for the notice, the applicant is responsible to print and securely attach the notice to the permitted tree. The notice must be posted 7 days prior to the removal of the permitted tree, and as much as possible, it must be visible to the public. And the notice must be kept legible at all times, so it should be laminated or protected from the elements. Okay, so this chart summarizes it all. For non-development situations, for city trees, a TIR may be required. For private trees, a TIR will always be required. The application fee for both city and private trees is $150 per tree, up to a maximum of $750 each. For city trees, the compensation will be the value of the tree removed plus $400 for a replacement tree. For private trees, it will be a 1-to-1 tree replacement ratio. For infill development and demolition situations, a TIR will be required for both city and private trees. The permit fee for both city and private trees will be $500 per tree, to a maximum of $2,500 each. The compensation required for the removal of city trees, again, will be the value of the tree plus $400 for a replacement tree. And for private trees, it will be a 2-to-1 or 3-to-1 replacement ratios, depending on the size of the tree removed, or $400 per replacement tree not planted. For site plan or plan of subdivision situations, a TIR is not applicable. A tree conservation report will be required as usual. The application fee is rolled into the development fees for those applications, and the compensation will be determined through the landscape plan process as a part of the development application review. Tree protection and retention is our primary goal through the new tree protection bylaw. Tree protection is referenced in several places in the bylaw. However, Part 6 of the bylaw is dedicated to tree protection specifically. This new part of the bylaw, and it was added so that it is more clear as to what tree protection means, and so that if it is a clear violation of the bylaw if trees are not protected adequately. With respect to tree protection measures, the bylaw references the requirement for tree protection fencing at the outer edge of the critical root zone, or as per the approved tree information report. The TIR could detail more extensive protection measures or mitigation measures to work within the critical root zone. This shows what would be considered as the ideal tree protection scenario. It includes details on the height of fencing, materials, distance from the tree, etc. We know, however, that it may not be possible to have this much space on small urban lots to install tree protection to this extent. So where it's not possible for work to be performed entirely outside the critical root zone, the bylaw includes provisions for the use of mitigation measures to limit the impact on trees. For these situations, arborists will play an important role in outlining tree protection strategies for clients. This specification is a useful tool and can be found on the city's tree protection bylaw web pages. The city will be taking a more prominent role moving forward on tree protection. Through the bylaw review, it was identified that this was something that was needed to be improved. In terms of education, we've done a massive overhaul of the tree pages on the city's website. They are better now and more informative. We have created information bulletins specific to interest groups and are sending them out. We will use the city's social media to promote the new tree protection bylaw. We will be issuing warnings where we aren't seeing adequate tree protection. Warnings can be considered for minor and correctable contraventions. And under the bylaw, we have the ability to issue stop work orders as necessary. A stop work order directs a person to cease work if a contravention has occurred, and these would be used to stop work to investigate a contravention or to prevent further damage to trees. Now we're going to go through two examples of process flows for how this will all work. The first one is for a regular application, unrelated to infill development. First, the applicant will submit the application online, so the TIR. The forestry inspector will review the application. The inspector will contact the client to discuss the project, conditions, compensation as necessary, and the tree permit decision is made. If monetary compensation is required, the invoice is sent. The compensation will then be paid to the city. The tree permit is issued and the forestry inspector confirms that all conditions of the permit have been met. And the permit and notice are posted prior to tree removal as per the permit requirements. The next process flow is for an application for tree removal in an infill development scenario. An infill development may start with a committee of adjustment decision, which will now include the consideration for trees. At the building permit or at the C of A stage, it's strongly recommended that the developer do a pre-consultation with forestry prior to submitting an application. This would be an opportunity for the city to set expectations for tree retention on a site. Moving on, the building permit application is submitted with the long tree information report, or the full tree information report. If there was a committee of adjustment decision relating to trees, that must be reflected in the building permit application. The forestry inspector reviews the application and contacts the client to discuss tree protection and any site-specific conditions. The tree permit decision is made. The monetary compensation is determined and an invoice is sent, and the compensation is paid to the city. The tree permit is issued with conditions, and the inspector confirms that all conditions of the permit have been met. The permit and the notice are posted prior to the removal of the trees as per the permit requirements. And the forestry inspector will monitor for required tree protection and tree planting over time. For more information on the new bylaw, you can visit the new web pages dedicated to the new tree protection bylaw at ottawa.ca/tree bylaw. You can refer to the tree protection bylaw bulletin that was sent to you with this presentation that is specifically prepared for arborists. You can read the city staff report that details the tree bylaw review and why a new tree protection bylaw was created, and a link to that is included in the email that sent you this presentation. You can call 311 with any questions at any time, and you can email urbantree@ottawa.ca for any detailed questions. Since this is all quite new information, if you have any questions, please email. If you can get any questions in to us by the end of day, Monday, December 14th, we will pull together a Q&A document and send it out to the full group before the holidays. But of course, like I said at the start, please email with questions at any time. Thank you so much for your time.